Hola, buenas tardes. Muchas gracias a todos por estar acá. Eh, esta vamos a hacer un conversatorio acá con el juez, Siamen Todd. This conversation is going to be both mainly in English, but also in Spanish. If you want to make questions, you can of course you can ask them in Spanish. And thank you very much.
Then they got no response from me.
Yes, there will be no response. Yes. So thank you very much for being with us this afternoon. This is part of the Judges for Chile initiative, which is unfortunately, not all of our students were able to come here because they are in their practical course this afternoon. But this is gonna be recorded, so they can follow them afterwards. Okay. So I'm going to introduce our professor here. I have already in Spanish, Tiamen Todd nació en 1971 en Salzburg, Hungría. Estudió Derecho en la Universidad de Szeged, Hungría, licenciándose en 1994. En esa misma universidad continuó sus estudios de doctorado, defendiendo su tesis en 2001. En 1994 comenzó su carrera profesional como jurista en la Oficina de Asuntos Europeos, integrada sucesivamente en el Ministerio de Relaciones Económicas Internacionales, en el Ministerio de Industria y Comercio y en el Ministerio de Asuntos Exteriores. Entre 1997 y 2001 ocupó el cargo de gestor de expedientes de la Oficina Internacional de la Autoridad Húngara de Defensa de la Competencia, transformándose en miembro en 2001 y asumiendo entre los años 2003 y 2009 como presidente del Consejo de Defensa de la Competencia. Durante ese último periodo, desempeñó el cargo de vicepresidente de la Autoridad Húngara de Defensa de la Competencia. Entre 2009 y 2022, ejerció la profesión de abogado, centrándose en materias de derecho a la competencia. A partir de 1999, inició su carrera docente en la Universidad Católica Pázmány Péter, Hungría. Entre el 2010 y 2013 asumió como vicedecano responsable de investigación y relaciones internacionales, de 2013 a 2014 de asuntos estudiantiles y desde 2015 de relaciones internacionales. Fue nombrado profesor titular en dicha casa de estudios el 2018, es autor de numerosas obras y publicaciones en libre competencia, y desde el 6 de julio del 2022 fue nombrado juez del Tribunal de Justicia de la Unión Europea. Entonces, él tiene una cualidad bastante importante, que es que ha hecho una carrera que ha vinculado el ejercicio profesional, el servicio público y al mismo tiempo la carrera docente, y desde hace 2 años, algo menos, está como juez en la General Court of the European Union, para decirlo. Entonces, eso es quien está acá. This activity is going to be informal, meaning that we have already prepared 4 to 5 topics that we will be developing this evening, but also here Tiamen is free to complement, to add new things, and after you are also free to prepare any questions that you may have. Okay, so let's start. As we saw already, in your professional career, you have managed to integrate aspects of teaching, public service in governmental entities, and also private practice of the profession at international law firms. Could you comment on your professional career and what are the experiences that marked you the most?
Thank you very much. It's a great question to kick off the discussion. Well, from my CV, can you hear me? From
Yes.
my CV, you might have realized that I'm not a usual judge. Don't know how is it in Chile. In my country, most of the real judges, they start their career after university, just like some of you may consider it. And then year by year, starting from the bottom, they work themselves up to some level. So this is the normal way of life, the normal path of a judge, not only in Hungary, maybe in most European countries, continental countries, maybe also here in Chile. One difference is when you look at the highest level. In Hungary, you have a constitutional court and a Supreme Court. To become a judge there, you don't necessarily have to climb up the ladder. So many Supreme Court judges, they may come from public administration. They were, for example, a deputy state secretary somewhere, and because of their skills, they are hired by the Supreme Court, where they become real judges. And the other is also true for the Constitutional Court, which is more like a political process to get into the court. You are voted by the parliament, by parties, but they're not. Constitutional judges in continental Europe are not always normal judges. They are more than judges a bit. So I think I was quite blessed in my career so far that I had the privilege to spend some time at most of the typical legal professions, which you can imagine you would like to work for. So, and in each of these phases, I learned something, I believe, which helped me to become, I hope, a good judge now. So to start with at the end, I've been a judge for not even 2 years. So I'm very, very junior judge. You please filter everything you are hearing from me with this in your mind. So there are other judges at the court who are more skilled and more experienced in these topics. So, but I do have the benefit to have spent some time in other legal careers, which I believe is very important for a judge. And maybe later we can talk about judicial strengths, what makes a judge a good judge. I think this is one important segment, that the more experience you have about life as such, about different segments of the life, the better judge you will become after some age. So when, for example, I started my work after university as a civil servant, working for a ministry, which at that time was involved in preparing the accession process of Hungary. It was in the mid-90s. You were born? Not last century. Oh, I'm old man, come on. So at that time, it was a big thing in Hungary, a historic thing. We were just like here in Chile in 1989, 1990, we had big developments. We detached ourselves from the communist Soviet Union and became again an independent country, trying to navigate back to the western part of the world. And becoming a European member state was regarded by everyone, basically, as a symbolic step which we have to make. And I had the privilege to contribute to that process as a very young civil servant, working on diplomatic relations with the European Union at that time, working on competition law, anti-dumping, so economic matters. Well, in such a position, one can easily learn virtues, values like modesty, right? If you are the youngest, the beginner in whatever job, you will easily learn that you have to be modest and you have to be ready to learn from the others, and you have to be a good team player as well. And that's also true not only for judges, but every legal career you will choose in your life. Almost immediately, I also started to teach competition law in Hungary, so mid-90s. And that helped me, this teaching career, first as an invited lecturer, just one course per week, then later more and more, first in Hungarian, then in English as well. That helped me a lot, especially to become I don't know if I'm a good orator or not, if I can speak well or not. I have my doubts, as I'm a modest person as well. But this helped me indeed to have the courage to speak in front of people like you. Maybe it's difficult to imagine, but when I was a student like you, I was one of the shyest. I always try to avoid situations where I have to stand up and speak, which is, of course, you can imagine, not a very good attitude to a lawyer. As a lawyer, you have to be brave. You have to have the skills, to stand up, to speak for your client, for yourself. And during the academic studies, I did not really master that ability. But with the help of teaching, from not immediately, but months after months, it helped me a lot to have this courage to speak in front of people. And well, later on, when I started to work for the Hungarian Competition Office, which is again public service, but the Competition Office in Hungary, like in many countries, is a special public office. It's an independent one. And the position I had there after a few years was like a decision-making position, like a quasi-judicial position. It's something like your cartel court here is in Chile, which we were doing as civil servants, as members of the Competition Council. So there again, first I was a member of this council, later I became the president of the council, kind of representing, organizing the work of the council. There we worked together with economists. Also, that was interesting and good experience. Usually we had 4 lawyers and 3 economists working on competition law cases. And that was both a challenge, but also a good experience to work with non-lawyers. There are not much differences, not huge differences between economists and lawyers. In some cases, I always have to confess that sometimes the wisest decisions were handed down by our economist colleagues and not always by lawyers. In some cases, the economists worked better as lawyers than we lawyers did. It's because of their special mindset. But again, working as a member of a team, that was very important in that position. And of course, mastering this attitude of being independent, impartial, objective. This is what a council member in Hungary had to be. We were not formal judges as such, but we were also nominated by the president of the country, like judges are, and we were independent by law. So we were not able to, we could not have accepted orders from the president of the office, from political parties, from whoever. So when we worked on cases, we worked like judges in 3 or 5 member panels. And this part of my life, which was 2 + 6 years, this was maybe the one which helped me a lot in my present career as a real judge at European level. Because the working methods, this independence, impartiality, that you have to be careful with clients, you have to be careful what you say, what you not say. That these things I learned at the competition office. And finally, once I left the competition office after the expiration of my term, then I became, in addition to academia, as a practicing. Is it possible here in Chile to become a professor and also practice law?
Yes.
In parallel? So in Hungary, it's quasi-obligatory because the salaries at the university are not too high. So if you have a nice family like I have and you have to look for them, then you must have a second job typically in the public or in the private, unfortunately. So there I was a lawyer at a big international law firm. I mean, the Hungarian subsidiary of that big international law firm. I was not a usual attorney because I was not young at that time. I had already experience. So I came in at a higher level within the law firm, which had its advantages, of course. But I still worked hard on myself on cases. I typed the submissions to the courts on my own. So I did some real attorney work as well. Here, what I enjoyed most was maybe that I could have discussed competition law issues with real people, with real businessmen. So not only on paper, in theory, but you could really have discourse with businessmen and think about, and you could realize how they think about life, what is important for them. There, if maybe you become a practicing lawyer like this, it will be very important to master this ability to be passionate, to be open-minded, to be able to step into the shoes of your clients, to be, maybe empathy is the best word for it, to be empathic and not just think about your own things, which you would like to say to the client, but put yourself into his or her shoes. What does she or he expects from you? And this kind of thinking, that's also important. Maybe not for a judge. I think a judge doesn't always think about what the clients want from them. That's not, at least it's not the most important thing. So thanks God, I had this nice combination behind me, which may help to become a good judge at European level as well.
Thanks. So you have highlighted very interesting kind of virtues as well. So the importance of being modest at the beginning of the career, when you are the youngest lawyer in a team, then the ability to speak out and to be able to speak in public situations. And also you emphasize the work with non-lawyers, like the economists. In Chile, we have the same. El Tribunal de Defensa de la Libre Competencia is integrated with both lawyers and economists. And also the attitude of being independent. That's something that you highlighted, as well as the passion and the empathy that you or one has to develop when dealing with clients. Sometimes before entering into real practice, you tend to analyze the cases, but from the paper or from the norm, and not going down to the interest of the particular case, the interest of your client. So that's another thing that you have emphasized. But then, why did you decided to went to the General Court of the European Union? And if you can tell us a little bit about what is the role of the court.
Yeah, so there could be a short response and a longer one. I choose the longer one, obviously. The short question, why I became a judge, because I was called, and I said, maybe, then I said yes, and then I was selected, and that's it. And I'm doing this. The longer story is, if I may start, I don't know how much you know about the court where I'm working, so I don't think too
We
much.
don't.
You don't have to. You are in Chile. We are in the other part of the world. So a few ideas about the structure of the European Court of Justice. It's also a complicated concept for Europeans. So if you think that you are lost, don't blame yourself or me. It's just a system which is a bit complicated. So when we say that we have a European Court of Justice, in fact, it means two courts. So, and it's a language problem here as well. In English, we call the court where I am, it's the General Court of Justice. In French, we would say it's a tribunal. Maybe the Spanish version would also be tribunal, which reflects a specialized court. No, it's not. That it's
in Chile we have the Tribunales de Familia, so family courts.
Yeah, so it's a specialized, it's specializing in a certain area. No? It's a wide word. Okay. Words are important. In my language, we don't have the word tribunal for court. Yeah, just court. Every court is a court. There are no tribunal courts.
There are synonyms in Chile.
In Chile. Okay. I had decided that maybe tribunal is something narrower or specialized, or maybe not. Good. So this is the court where I am. And there is a second court, which is called also Court of Justice. Not a fancy name. European Court of Justice, and its two institutions build the European Court of Justice. And the relationship between them is, well, it's a bit hierarchical. So there are cases where my court hands down the first judgment, and that can be appealed to the Court of Justice, where the even wiser judges would hand down the final verdict. And they can only appeal on questions of law, like in most appeal system. If you learned about these things like administrative courts, constitutional courts, if I may use these abbreviations, my court is more like a high-level administrative court, whereas the European Court of Justice is more like a constitutional court, as a rule. Being an administrative court means that you review the legality of decisions adopted by the administration. At European level, who is the administration? So we have many potential targets. These are the council, the ministers. So it's a high-level political body adopting regulations, directive. We have the European Commission, which is a kind of government at European level. For example, when they adopt in a competition law case, a big fine against American or European companies, it's imposed by the European Commission. And then Google or Alphabet or Mercedes or whoever will come to us to sue the Commission, saying that that decision is unlawful, it's bad. And we have lots of European agencies as well, specializing on pharmaceutical things, chemistry, so approval of chemistry products. There's a maze of such agencies who adopt decisions affecting the interests of companies typically. And then these companies can turn to us and sue the agency. Also, we have many of our cases relate to intellectual property law. So we have in Spain, in Alicante, European Agency for Trademark matters, trademarks, designs, things like that. If they adopt a decision which hurts the interests of some companies, then they again turn to us. So we have a wide variety of cases. And if you look at the subject matters, it's even more widespread. So we have many labor law cases. I forgot to mention that. So we are also a labor law court. Why? Because at European level, we have many civil servants, European civil servants who work for the Parliament, for the Commission, for the European agencies. And if they have any labor law problems with their employer, then they turn to us, to the General Court. I'm luckily not involved in such labor law disputes. We have an internal separation. Specialization is a better word. So there are chambers which deal with these labor law issues. And the other specialization in which I'm involved is the intellectual property cases. So of these two, we have the most, maybe. Labor law, intellectual property. We also have many competition law cases, state aid cases, cases relating to agricultural regulation. They are awful, usually. Very technical, very long. We have lots of bank regulation cases, as we have a European level banking regulator as well. In my chamber where I am, we have many cases relating to foreign policy, most precisely sanctions. This is the journalistic word. This precise legal phrase would be restrictive measures, which, for example, I don't know how Chile is active, but the big jurisdictions like the USA, UK, European Union, in order to enforce their foreign policy priorities, they can adopt validly under international law restrictive measures targeting sovereigns and parts of that sovereigns like companies, private persons. So in our chamber, we have on a daily basis, we have cases involving Russian oligarchs or big companies who suffer the restrictive effects of sanctions imposed by the European Union institutions. And that's interesting, isn't it? That we have non-European individuals maybe bad people, maybe good guys, you don't know. But they are not Europeans, that's for true. They are living outside, far away. They can come to us as plaintiffs. As plaintiffs, and they make us work, European judges. And they sue before us a European institution, the highest level European, the Council of Ministers, the lawmakers, basically, arguing that the council committed an error when they were blacklisted. So it's a quite unique setup, isn't it? It's very unusual. In some countries, maybe also in the US, there's even a jurisprudence that these kind of matters should never be subject to legal review because it's politics, it's foreign policy. Nothing for judges to be involved. In Europe, we have a different attitude towards that in order to protect human rights, basically. So even Russians, they have human rights, of course, they are humans. So we try to protect them in Europe against European institutions.
And you have authority to overrule some rulings of or acts of the council?
Yep. And in that manner, we are more like a typical administrative court. We are a bit closer to a constitutional court.
Yes.
So part of our job is a mixture of, we have different seasoning. It's a big plate, and you put in some administrative law, some labor law, constitutional law a bit. We also hear damage actions, where plaintiff can sue the commission or a council for causing damage. For example, these Russian oligarchs, if they think that they can win, they would also demand monetary damages because their rights were hurt by an unjust European measure. And when you adjudicate such a question, you act like a civil law judge. You have to think like a civil law judge. And that is a challenge. I have to admit that most of the time you're an administrative judge with a special mindset. Sometimes you have to think like a constitutional judge. In other cases, you become a civil law judge. So it can be a bit not frustrating, but it's a challenge indeed for me as a new judge. And it does happen. So back to your question, we do have cases where these Russian plaintiffs, they may come from other sanctioned countries as well, but we have Russian cases in my chamber. They are successful, and if they can prove that the council was not legitimate, was unlawfully putting them on the blacklist, they didn't merit it to be there, then we annul the council regulation. And that's good news, of course. It seems like good news. What happens in practice, and this is the less positive sides of being a judge, is that almost immediately the council would adopt a new decision, a new regulation. More, modifying the reasoning, maybe adding some more evidence, some more newspaper articles involving that oligarchs. So they can easily avoid the negative impacts of such a judgment. And then the plaintiff would come again and again and again. So we have now cases, this war is going on for 2 years, and we have now cases in which we hear the 4th or 5th sanction, because the sanctions are for 6 months always. They're limited in time. And after that, they have to be renewed, and they are typically renewed. So it can lead to a maze of litigations, but so much for restrictive measures.
Very interesting.
And I have not responded to your initial question. How do you become a judge like that? I have to confess, when I was a young lawyer like you are, it was maybe on my distant agenda. Maybe I would be the lucky one who could once go to Luxembourg. Luxembourg is the place where the court sits. And maybe I could become, that's one of those famous judges whose judgments are taught at universities. And maybe I can contribute to the development of European legal system. But, when you are in the work, when you are doing your daily work, these dreams sometimes disappear. So it happened to me as well. And, well, after many years working at many interesting jobs, I just never ever thought about becoming a judge. And it happened really like this, that about 2 years ago, I received a phone call. I think I was just delivering an It was still the COVID area, so we had
Mhm.
online lectures delivering from home. When I received a call from an old friend of mine, and that's an important topic, we might come back to that, the networking. So there was a deputy state secretary at the Minister of Justice who was responsible for selecting candidates for a judge position. And he called me that, are you not maybe interested in this? We need a really good person who is independent and not linked to the political parties, to the government. And so that's how it happened. So in Hungary, we have different, that's interesting. So even though we have different procedures, it's regulated by national law, how you can become a judge at the European Court. We don't have a single European entry exam. So it varies from country to country. In France, in Hungary, we have an informal process for selecting judge candidates. In my case, it was an untransparent procedure, very undemocratic, I have to confess. So I may be a judge now, but as a result of an undemocratic selection process, we had kind of these secret invitations. I don't know who else was involved. I know that there were 3-4 other candidates who were heard by the Minister of Justice. We had to submit our CVs, things like that, of course. We were heard by the minister. Then ultimately it was the government who approved me as a candidate. I was also heard after that in the Hungarian parliament before a small committee. Almost no one was there. It was the last day of the parliament before the summer session, so not much interest. And then I was proposed, and then it's a kind of gathering of the member states who unanimously decide about the judges. And before that, and that's an important thing, I would mention this, for a couple of years, we have an interesting committee. It's called Article 255 Committee because it's in the treaty, founding treaty. And that special committee has this task to filter, to select, in a way, to examine, in fact, the national candidates. And I had to go through that committee, and that was really, really fearsome. Even when you're at the age of 50, being examined, that's why I became a professor. I can sit on the other side of the table. And at the age of 50, then you are examined by the most serious judges you can imagine at European level. And you are scared, of course. You have to be prepared to answer questions about European law as such. It's a huge area. I just know about competition law, of course. So I had to prepare 3-4 months at least. And I had to do that in French as well, not only in English. And for me, French is still a challenge. So, and this committee is very important. It's because of these different national procedures. This is the common denominator. So it does happen that this committee gives a negative opinion. And in that case, the member states would not accept the candidate. He would be refused. It's a quite unpleasant situation. I was potentially also facing, and it does happen. So, for example, before me, the previous Hungarian candidate was turned down. In Slovakia, that's also, of course, a member state. They have now a sequence of 5 or 6 candidates having been turned down. So they are taking their job very seriously, these members of the committee. So that's how you can become a judge. National nominations, but there is a European exam, which kind of filters out the political nominees, which are not welcome, of course.
Thanks. Now I would like to move on to a different topic. We have here in Chile, we have a very interesting discussion regarding the role of the judge, meaning that what has to or what is the function, the role of a judge in case where you see some kind of conflicts between or subjective conflicts of the judge, internal conflicts of the judge between applying a law which could lead to a subjective, unfair decision to the particular case. You know, in Chile, that is something that is quite I don't know, current. You know, here we have a lot of news, a lot of discussion regarding the role of the judge in particular case where the law could be some kind of obscure or not clear, but the sense of justice to the particular case, it is very clear to the judge. So, or in other cases where the judge, it's fairly clear, you know, so I think anyone could know what the judge, what the law says, but also in that cases, the judges applying general principles, applying sometimes even the Constitution, they go through and they go over the law. So do you have any experience dealing with this kind of conflicts, and how do you manage to resolve them?
Yeah, personally, I have just very limited personal experience. Yet the topic is very important to discuss. And well, the easiest answer is maybe that the role of the judge is to decide the dispute before it.
According to what?
According to the law, of course. According to the law, what is the law? And then we can continue the discussion. Maybe the response depends upon two big issues which vary from country to country, from situation to situation. First, that which kind of court are we talking about? Which kind of legal field are we talking about? There are kind of boring legal fields in corporate law, for example. I don't know what is the situation, the system here in Chile. In Hungary, when a corporation is being registered, it's also a judicial exercise. We have judges who keep this company register up to date.
Oh, in Chile, no.
In Chile, no.
It's a public officer as well.
Yeah, but you can imagine if a judge is doing that, it's quite straightforward. Maybe not always straightforward, but a job where you have strict, clear rules. It's a bit administrative, as you said. In such a situation, the role of the judge is not that complex, maybe. Yet the other extreme could be maybe a constitutional court judge who really interprets the broadly worded constitution based on general principles of law and fundamental rights. This is something like we are doing also in Luxembourg, to be honest. But that depends upon the legal field as well. Again, if we have in front of us an agricultural law-related dispute about, for example, in Europe, we give lots of funding from European level to member states, to agriculturals, to farmers, to raise cattle, to grow whatever they want. They get subsidies for that, which are attributed to member states. Sometimes member states breach these formalistic rules, how to avoid the European funding. It's complicated. I don't even myself understand all the details. So again, if you are into such a regulatory field where you have lots of detailed regulations and hundreds of pages, again, the role of the judge is also quite simple. So you have to read the law, try to understand it. It's a challenge because it's rather technical. You have to become first an agricultural expert. But then if you are through that, then it's a quite easy task to apply that law, to interpret that law. If you're in other fields of law, like I usually like myself, like competition law, where we have also very broad prohibitions, like you should not abuse your dominant position. Full point. Then how do you interpret it? Who is a dominant company? What is abuse? What is fierce competition versus abuse? And that requires a different mindset. And that brings me to the second big differentiation point, that which kind of legal system are we talking about? Is it a common law-based system or a continental? How much role do we have for precedent, for written law? At European level, it's a mixture again. It's more like, on the basis, it's a continental legal system with written law, with regulations, treaties, directives, whatever, you name it. But maybe also because of the influence of common law countries being member of the European Union, we also have a kind of common law thinking with case law being there, in addition to the layer of texts, of legal texts. So in the field of competition law, you do need this case law-based thinking approach, working with principles, with economic principles, with fundamental human rights principles. And that is a more interesting, thought-provoking field of interpreting law, more challenges for judges. This is an area where you have to be cautious indeed, not to overplay your role, not to substitute your personal individual beliefs with what is good for society. As if you're a judge, you are kind of balancing, I believe. You try to balance between, you have to interpret legal texts which had been written maybe ages ago. And now we are here in this society with these problems. How do we bridge the gap between these two things? Sometimes you have to bridge the gap. You have to be a bit innovative. But to what extent can you do that? And here it's important to know as a judge of what is good and what is bad, not only from the individual point of view, but from what is good and bad for the society in which you are living. For us as European judges, we have to be aware what is good for Europe as a process, as an integration process, what is good for European citizens. And that thing we should bear in mind. That's a ancient. You could never, maybe you could never respond to this question. What is the relation between law and justice? Is it the same side of the two coins, or is it different? I would try to represent a position that I would tend to find to be just within the framework of the law. So I would never try to go beyond the text, for example. If we have a clear text, even if I don't like it, I would never be as activist to adopt an interpretation which would infringe the text of the law. But if you are within the text, and within that text there are different options of which you could choose, then you should really take into account what are the interests of the society in which you are living as a judge.
Very interesting. It's a very interesting topic. Yeah, but that gives something, a guideline, to be within the borders of the law and to choose if the law provides the alternative to move, but always within the scope of the law.
May I maybe just another example for that?
Sure.
So what is just or lawful, or what is justice dilemmas? I think in Chile, it's a competition law example, sorry about that. In many countries, we have a system, what we call immunity or whistleblower system. It's coming from the US, like many things. Yeah. I can recall when it was introduced in Hungary by legislation, luckily, and not by interpretation. It was a big debate also in the parliament between various parties. But is it a just thing? So the essence of a leniency program is that you are a cartel member, you're a bad guy, a quasi-criminal, but if you acknowledge it before the competition office, it's a Catholic thing, right? You go to church, you confess, and you have to promise that nevermore. And if you do that, the reward in Europe is that you will not be fined. You might face damage actions later, but you will not be fined by the competition office. So this is the scheme. So it's lawful, but is it also just or not just? There were many people who were arguing that it's not just. Yeah, he's a criminal. Why is he not punished like the others? Understandable. On the other hand, we have important public interest that cartels are secret arrangements. If you don't break the silence with motivation, you would never have cartel cases. If they are doing the cartel, if they organize the cartel professionally, which they most often do nowadays. So balancing between these two social interests is a difficult thing. Ideally, this balancing is done by the legislator, by politicians. This is their job, isn't it? To know, to feel what society wants. If we are not in the lucky situation and the politicians leave the question open, sometimes they do that to adopt the legislation quickly. Let's leave it to the judges to interpret the law. Then judges will be in a more difficult position to decide what is just and what is unjust. So.
Thank you. Very interesting topic, this one. And okay, so now we're facing our last questions. So moving towards the principles, values, and attitudes that should characterize a good judge. What do you think about it? Which one or which ones?
I would love to ask the students typically in such a, if I receive a difficult question, most often students know the answers much better than a skilled presentator. But if we allow me just to talk about virtues, going back to this topic, the first one I would emphasize is practical wisdom, common sense. Just be a normal person. You should not forget what you learned at university, of course, the many technical rules. But if you can work with this common sense, which many people are lacking, especially if they're in high positions, if they learned a lot, if they are getting detached from reality, then that can be a big problem. And so that's maybe the most important thing. How you can achieve that, it's very difficult, of course. Maybe time is a crucial factor. I always envy those judge colleagues who become judges at the age of 30. Oof. I was, when I started my position, that high-level position in the competition council, I was also very young, 34 maybe. And that was maybe too early, to be honest. So you need some time, some real life experience to master this. It will come. So this is my good message to you. It will come with time. Impartiality, of course, it's very important, but it's a basic thing. I should not talk too much about that. Being prudent is, of course, also very important. If you are a judge who works in panels, if you're not a lonely judge, but if you work with other judge colleagues, being a team player is very important. To be open-minded, to try to you have a strong position. Most judges have. We are very independent persons, very knowledgeable. We know the law, we know the life. But there are other judges with the same background, and they may have different solutions offered to the same problem, different approaches. So you have to be open-minded to be able to accommodate these differing thoughts. And you have to be able to produce a judgment which reflects the common denominator of these divergent approaches. Maybe I have not mentioned this. At European level, we always hand down just one judgment. There are no dissenting opinions. Like in most Supreme Courts or constitutional courts, it exists, which means that we try to always build a consensus behind the judgment, if not possible, a majority. But it should be a consensus ideally, which means that we have to formulate a text which is acceptable maybe they will not like it, but they will accept it as. So that these are maybe skills which are necessary.
Yes, you have a questions?
You have a question. Thank you very much for the lecture. I wanted to ask you about social life and being a judge. Because everyone
Parties.
knows the example, yeah, of
Yeah,
the
yeah, yeah.
Prime Minister, the Finnish Prime Minister that had a problem because she
Yeah,
went out.
yeah,
So how does a judge manage to have a normal social life and being at the same time a serious person, and they have to show something that
It's very topical. You just make me think about what I should do next week. In fact, we are organizing a big party in a building just across the court with a Hungarian colleague of. We are celebrating the 20th anniversary of Hungary and many other countries joining the European Union. 1st of May is a big date. And then the day before that, we are organizing a big party with lots of dancing, Hungarian food, wines, and I'm sure I will be dancing there. I hope that I will not be filmed. But seriously speaking, we have some, of course, codes of conduct. At most courts, there are written rules how you should behave. I don't think we have special rules on that, but now that I hear your question, maybe I should double check. What I can recall, if I may tell you such secrets, when we have a judicial meeting celebrating the end of the year, we also have judicial parties, and there are some colleagues who dance quite well. There are colleagues who play the piano very well and are like professional singers. Yeah, but it's among judges, so maybe a different setup. You might be right. I will have to be careful how I dance. That's true. But seriously speaking, we have rules about where I can speak. To come here, I needed, for example, a previous approval. So my time outside the court is kind of monitored. I have to explain to the judges, to the colleague of the judges, why I'm not at the court and what am I doing there. So in theory, they could discuss it with me. They could raise some concerns. Then maybe I would think about that. But it's working. It's working in practice. I also have to be careful what conferences I visit. So, for example, if a workshop is organized or funded by one single law firm, mainly to its clients, then I should not appear there as a judge, because it would give the wrong impression that maybe that law firm is so influential that they can invite a judge who even comes, who even speaks there. So if, we should not be biased like this. It's a challenge, I have to admit, but luckily during this short time I spent at the court, I never had to face problems because of that. But I will read the text again about social life and dancing publicly.
Thank you. Yes, please.
Nice to meet you. My question is, it's more about the General Court of the European Union. The European Union is known for being one of the few successful cases of establishing an international jurisdiction because of the legendary issue of compliance. And I think that the European Union is like a rare jewel in this matter, because you have managed to establish a jurisdiction that actually makes binding decisions that are generally respected. And that is so uncommon.
Yeah.
And in times like this, times of crisis in general, international cooperation and international jurisdictions are being questioned. So how do you see the future of international jurisdictions? Do you think this case of the European Union could be replicated, or this is the only opportunity we'll ever have?
We are a special animal, if I may say so. And that relates to the nature of European law, maybe, of which the European courts are the guardians, the most important guardians. So European law is somehow positioned a new legal order, have to be careful with the metaphors, which is somehow in between the traditional national law and international law. European law was born like international law. The treaties are adopted by sovereigns. It's international law, basically. But at the same time, this is our constitution within European law. So these two are somehow mixed together. We also have judgments saying that European law is not a new subsection of international law, but it's part of domestic national legal systems. It's difficult to imagine, but this is in those famous judgments. So the message is that to national judges, to national actors, that please don't regard European law as something alien, as something international, something suspicious. It's something like your own national law, because indirectly, ultimately, your national representatives did take part in the adoption of that European law. And we have, of course, fancy rules about if there's a conflict between the two laws, then European law should prevail. So again, no hierarchy, but yes, it's a kind of hierarchy. It's also important that at national level, we don't have specialized European agencies and European courts. Compare it with the US system, where we have federal district courts, federal appellate courts, in addition to the national member state courts. In Europe, it's different. We have Hungarian courts, German courts, who at the same time apply not only national, but also European rules. And with that approach, we kind of really make it a reality that the distinction between national and European law is not that sharp. By now, in many legal fields, judges, practitioners don't even realize that the law, what they are talking about, is European or national. We have this system of directives, for example. To give you a concrete example, in misleading advertising, it's a fancy topic, consumer law, competition law a little bit, we have general European rules in the form of a directive adopted by the Council and the Parliament. And the directive is implemented, it must be implemented into national law, like an international treaty sometimes is implemented into national law. So we have now 27 separate national regulations on unfair commercial practices, misleading advertising, practically. In each country, the national administration, judges apply their national law on misleading advertising. They don't even realize that what they are applying, enforcing, is essentially a European norm, because behind the national law, there is a European law. So this way, national law and European law go really hand in hand nowadays. And because of these reasons, it's a very special animal. So it's not like the European Criminal Court or other international courts. Well, without trust, without submissions, these would never work. I have to also add that also at European level, it sometimes happens that member states don't comply. It happens, not Hungary. Other big famous member states like France, Italy, we have cases where, for example, there was a state aid dispute. So France gave state aid to its enterprises, which was prohibited by the European Commission, being anti-competitive. And then there was a procedure before the courts, general courts, European Court of Justice. The European Court of Justice, after 6 years, saying that the Commission was right, France was wrong, you should recover, take back the unlawful aid. But then France says that, oh, I can't do that, it's too difficult, it's too complicated, it was too long time ago, I will not do that. It happens, but then we have another legal procedure for that. And then the Commission, yes, and then the Commission, then the court can impose fines on Italy, on France, on whoever, for not implementing the judgment. Yeah, but it's ultimately about trust. So if you want to be in the club, you will have to accept the rule of law. And if you're outside the club, so if you're not a member of the EU, then these things are more complicated. Do you have it at South American level, such
No.
a court
No, we
like
don't.
South?
Yeah.
Yeah. Yeah, why would a sovereign do that? Why would I
Sure.
give up my sovereignty? In Europe, it's a bit easier because we have a common goal. We want to become European. We
Mm.
realized after the 2 bloody world wars that otherwise we would die, to put it simply. So
Yeah.
maybe you have different histories here.
Right.
Sure.
Yes.
Sort of more like professional advice. What would you recommend? You seem to have had a very wide interdisciplinary career. What would you recommend to new graduates and students who want to pursue like a wide career as well? You know, be able to move between the public and the private sector.
I don't know which is the, I would suggest to try both. I have also grown up kids, like lawyers and psychologists, and they are doing the same thing. They started as private lawyers, and after 2 years, my son now is switching back to a public office, to a data protection office. So it's important to try both. I don't know which is the best sequence. Maybe if you start with the private sphere, it's more demanding. After the university, when you are hot, when you want to fight, you are lots of time because you don't have a family maybe yet, then maybe it's a better start. And then to go back into the more peaceful public, I don't know whether it's more peaceful public life, and then to go back again. And so it's not bad to have this revolving door system like they have in the US, for example.
Thank you. Thank you all for being here. Thank you, Professor. Now to close, I don't know if you want to say like a final, like what would you suggest to 1 or 2 students here who are seeking the judicial career, and then we're all free to go.
I don't have such wise pre-written statements. So do you really already have this firm intention to become a judge, or you're just thinking about, or at least in my country, maybe to become a judge, this was the highest level thing, what law students can aspire. This is the top. So, but which meant at
In
the
Chile,
same
we're trying to have that perspective, but in
Yes.
general terms, it's not something that normally like the good students are aimed at.
Huh,
that's
because
not-
it's not good money, or it's dangerous, it's not popular, it's not highly regarded.
It's not that.
Not yet.
It is highly regarded, but it's not as popular as corporate.
It's corporate. That's interesting. That's interesting.
Yeah.
But it's a quite different way of life, again. So I'm not saying that corporate is here and judges are there. Both are important. Different scales. Yep.
Thank you. Thank you very much, Professor. Thank you all for being here with us this evening. And I think we should give a round of applause to here. Thank you very much. Nos vemos, muchas gracias a todos por venir y nos estamos viendo en otras actividades de la iniciativa Jueces para Chile. Adiós.